We've done yoga together too.
We have, yes. I think stress release, however you get it. Okay, in addition, we have Adriel Douglas, who was as Brenda was, teaching assistant in the fall of 2016. During 2015 and 16, she did clinical internships through the Domestic Violence Prosecution Hybrid in Albany City Court. She was the Moot Court Board Senior Prize Trial Chairs from 2016 to 2017, and Balsa's co-president from 2015 to 16. She then went to the Brooklyn DA's office and brought her wisdom there. But the Capital Region, I'm glad to say, called her back. She is currently the Associate Counsel for New York State Senate Democratic Majority Counsel's Office. Congratulations, Adriel. I don't think those guys down there could get the budget passed without your help. I'm amazed that you were still able to be here today. Please say hello.
Hi, how are you, everyone?
Delaney Reeves Knapp, another reunion of students who have taken the panoply of courses here from Professor Brieger, Professor Connors, and many, many others. Perhaps Dean Ouellette as well, is a second-year associate at Bond, Schoeneck and King in Albany. Her practice is focused on assisting nonprofit entities and not-for-profit organizations to meet their business goals and charitable and philanthropic missions. While attending Albany Law School, she was a student in the DVPH clinic with a placement at the Saratoga County District Attorney's Office. Her DVPH seminar paper, Fanning the Flames, Gaslighting as a Tactic of Psychological Abuse and Criminal Prosecution, was published in the Albany Law Review in 2020. I also want to add that when she and Rebecca Wager were co-chair of the Women's Law Caucus, they ushered in a new era in which affinity groups and the Women's Law Caucus really focused on making space and on multiple intersectionalities and becoming allies with others at the law school. And I'm happy to say, Delaney, that your legacy has continued to today.
Thank you. It's very kind. Thank you all for having me.
All right, and I think I have finished with the student and with the alums, all the alums. The next two judges are on the faculty. One of them happens to be the dean of the law school, but she loves when she's in her faculty role and when she gets to be with students and engage with scholarship. Alicia Ouellette is the 18th president and dean of Albany Law School. As you know, she has championed the value of law schools as drivers of change in communities, society, and the lives of student and graduates. She's presided over the execution of a new strategic plan that we have seen come to fruition, and she has guided us through this pandemic in a way that is so stellar that she is known and is in a book now about crisis deeming. As a scholar, she focuses on health law, disabilities rights, family law, children's rights, and human reproduction. Her book, Bioethics and Disability, Toward a Disability Conscious Bioethics, was published in 2011. She has co-authored, it goes on and on, the list of her articles. She was a New York State Attorney General office, a law clerk to the Honorable Howard Levine in the New York Court of Appeals. And her original avocation prior to becoming a lawyer was as a social worker, and that has really served her well, both as a dean and as a scholar. And then finally, my, I think, accomplice in creating a panoply of gender and intimate violence and bringing these issues to the research and the curriculum of Albany Law School, Professor Melissa Brieger. And now I have to find my other piece of paper, my Melissa paper. Professor Brieger has been teaching at the law school for over 20 years, the University of Michigan Law School, then we stole her, and she's been at Albany Law School since 2002. She has dedicated her career to children, women, and families, and has practiced both in New York City and here in the Capital Region through supervision of clinical students. She is the recipient of about 10 different awards at least, so I'm just going to name one or two. The National Shonora C. Gilbert Award in recognition of her excellence in teaching in the Family Violence Clinic and contributions to the advancement of social justice from the American Association of Law Schools. The L. Hart Rights Excellence in Law Teaching Award at Michigan. And she's gotten every faculty award there is at Albany Law School: scholarship, research, and service. Her courses: evidence, family law, criminal procedure, investigation, gender in the law, children, juveniles in the law, domestic violence seminar, children in the law, and was the civil companion to me directing the Family Violence Litigation Clinic throughout the 2000s. Okay, that's enough from me. I think it's time for the show to begin. There could not be a more timely moment for us doing this, given the newest reports on femicide and risk to women, women of color, and non-binary individuals. So thank you all.
Okay, because they promised me I would not have to talk too much, I'm just going to ask Brittany if you are ready to go.
Yes.
Okay, great. So next up, or first up, is Brittany Bushman, class of 21, and she's going to be reporting on the credit reporting system is the new abuser, a look at financial abuse and bankruptcy's significance in domestic violence survivors' path to freedom.
Thank
Take it away.
you. I'm going to share my screen now. Okay, hopefully everyone can see that now. Well, thank you for that introduction, Nina. Hello, everyone. My name is Brittany Bushman, and today I'm going to be talking about how the credit reporting system is re-victimizing domestic violence survivors, especially when financial abuse is present, and how bankruptcy is often overlooked as something that can lead a victim to his or her path to freedom. I was actually drawn to this topic because of my past history as a financial counselor before law school. And it's something that was very intriguing to me, and I wanted to look into this. Financial abuse is one of those unnoticeable and invisible types of domestic violence, but it's extremely common. According to one statistic, those who experience domestic violence in any kind of form, whether that be physical or emotional abuse, 94 to 99% of those domestic violence survivors also experience economic or financial abuse. And not only that, financial abuse is cited as the main reason why men and women stay in or return to an abusive relationship. So what is financial abuse? Financial abuse and economic abuse is often used interchangeably, and the National Coalition Against Domestic Violence defines economic abuse as when an abuser takes control of or limits access to shared or individual assets, or limits the current or future earning potential of the victim as a strategy of power and control. Because economic abuse takes many forms, in my research, I use the term financial abuse to exclude certain forms of economic abuse, such as sabotaging employment or education. So some types of examples of financial abuse behavior is in controlling how money is spent, giving a partner an allowance, being excluded from major budget decisions, and as this presentation will underscore, using a partner's name, social security number, or other information to open bank accounts or other types of financial credit loans without their knowledge or consent, or even forcing the victim to obtain those types of loans. One researcher, Angela Litwin, has coined the term coerced debt in her research on the pervasiveness of financial abuse, and she defines coerced debt as all non-consensual credit-related transactions that occur in a violent relationship. And in my research, coerced debt was particularly important because coerced debt will have a direct impact on a domestic violence survivor's credit and his or her options to address that debt. And coerced debt can include not only credit fraud and theft, but also in addition to outright coercion, duress, intimidation, and inability to consent. So what is the credit reporting system? I include this slide as a bit of an overview for those that may not know, and I'll summarize what the credit reporting system is. It includes three main parts: the credit bureaus, the credit reports, and credit scores. What's known as furnishers, which are typically the creditors that you owe or any other type of company, such as an insurance company or your utility bill company, they will supply information to the credit bureaus about your accounts and about yourself. And the credit bureaus then gather that information and they create a credit report for each individual. And a credit score is then calculated from the information in that credit report. And not only do traditional lenders rely on credit reports and credit scores, but also home and auto insurers, as well as employers and landlords. And as this graphic shows, there are many variables that actually go into the credit score, with the top two being payment history and amounts owed, which are also the two biggest factors that coerced debt will impact. So why are there inadequacies within the current credit reporting system? Well, my research focused primarily on two main remedies that are available to domestic violence survivors. The first being splitting liability of certain debts in a divorce decree or similar separation agreement, and the second being reporting identity theft. On its face, these two options appear to help domestic violence survivors, but they ultimately fail to address coerced debt and financial abuse, and they both have significant limitations. When it comes to the liability of debt, debts are contractual liabilities to a lender. So a divorce decree, order of protection, or other similar agreement will not be enforceable against the creditor. So a recognition by a family court that coerced debt and financial abuse has occurred will actually only be a paper victory. And in some instances, divorce decrees or other similar separation agreements will include an indemnity clause, which means that you can go after your ex-spouse to recover any amounts that you paid on a debt that they were responsible for. But not only does this type of clause require the forethought to include it in the first place, but it also requires additional legal action to enforce. On the other hand, identity theft recovery also has numerous limitations because of how nuanced it can be. First and foremost, it's a difficult and long process to fix your credit. Identity theft recovery takes on average about 6 months and up to 100 or 200 hours worth of work. The Fair Credit Reporting Act allows for a permanent block of fraudulent information from appearing on your credit report and to prevent companies from collecting debts that result from identity theft. However, studies show that the credit bureaus do not always follow the Fair Credit Reporting Act. In fact, they also have the luxury of denying relief if they do not believe the consumer. This gets a little bit complicated, but the furnishers that I mentioned on the prior slide, they are primarily the ones responsible for investigating identity theft issues. And if they don't have an adequate investigation, or if they don't find any results of that information, credit bureaus will take the furnisher at their word and will deny relief to the consumer. First and foremost, the biggest issue upon identity theft recovery is that if a domestic violence victim was aware of the debt or was coerced into signing those loan documents, the identity theft protections under the Fair Credit Reporting Act will no longer apply. Which leads me to bankruptcy. As a brief introduction, there are two main types of bankruptcy. There's Chapter 7 and Chapter 13. And while the two types of chapters have significant differences for an individual, the main difference between the two is the opportunity to keep certain assets that exceed the statutory exemption amount. And the most important thing about bankruptcy is that under both chapters, it provides a mechanism for your debt to be discharged, which means that your personal liability to pay the debt is no longer enforceable. Another important doctrine of bankruptcy is the automatic stay, which is immediately placed upon the filing of a bankruptcy petition, and it protects the debtor from not only debt collection, civil lawsuits, civil judgments, but any other attempts to seize or control debtor's property. So why can bankruptcy help? Domestic violence survivors, they may not want to file a police report against their abuser for identity theft, particularly if they've had a rocky relationship with the police in the instances of their relationship, and they may not have the time or resources to fix up their credit. In addition, they may not just have the income to just pay it off either. And finally, the divorce decree or other agreement may be difficult for a domestic violence survivor to enforce. And while bankruptcy has a negative stigma, the limited options addressing the liability of a debt cannot be ignored. And the purpose of a bankruptcy is often described as providing a debtor a fresh start, as a way to start over and begin anew. And I think the idea of a fresh start is even more resonating to financial abuse survivors specifically, because the idea of a fresh start embodies more than just an adjustment to a debt column of that individual's balance sheet, or even just the budget. It suggests a behavioral component to the bankruptcy experience that gives domestic violence survivors a sense of their own ability to engage in not only a different set of financial behaviors, but their own set of financial behaviors going forward. So a domestic violence survivor will often find themselves interacting with the bankruptcy court in one of two ways. Primarily, my research focused on what happens when a domestic violence survivor files for bankruptcy, but there's also instances where a domestic violence survivor's abuser files for bankruptcy. Under the bankruptcy code, if a victim files for bankruptcy, that bankruptcy code does provide for the safety and protection of the domestic violence victim. For example, a debtor may exempt from his or her bankruptcy proceedings any reasonably necessary expenses incurred to maintain the safety of the debtor and his or her family from family violence, and these expenses are kept 100% confidential. In addition, the bankruptcy court is often referred to as a court of equity, and the judges do have some flexibility in addressing certain issues. For example, under the bankruptcy code, if a debtor does not keep or preserve adequate financial records, the court can deny a bankruptcy discharge. In one case called Henry Young in the Eastern District of New York, a court actually found that a debtor who was a domestic violence survivor was justified in not keeping adequate financial records, and she was allowed to continue with a bankruptcy discharge. So in other words, the requirements for filing bankruptcy seem to be more relaxed for domestic violence survivors. And then finally, the bankruptcy code does provide for protection against discriminatory treatment when it comes to private or governmental employment. And then additionally, while I didn't focus this directly in my research, and if an abuser files for bankruptcy, a domestic violence survivor still has protections. Two important things to note when this particular instance happens. In a civil suit or a criminal action against an abuser for domestic violence, those types of actions are specifically exempted from the automatic stay that I mentioned previously. Now, it would be remiss of me not to mention bankruptcy's own impact on credit. While bankruptcy has an impact on credit reports and credit scores, studies in this area actually reflect numerous inconsistencies as to the extent of that impact. In fact, it may not be as devastating as we may have been led to believe. For instance, one research study has shown that creditors repeatedly solicit debtors to borrow after bankruptcy, almost immediately after a bankruptcy discharge. Another study analyzing bankruptcy and credit over an 11-year period found that the recovery in a credit score was dramatic and actually took place immediately after the filing of bankruptcy for Chapter 7 and 1 quarter after the filing of a Chapter 13. Additionally, both Chapter 7 and Chapter 13 debtors were able to get new credit cards almost immediately after their bankruptcy filing. Now, as I mentioned at the beginning of this presentation, I used to work as a financial counselor and counseled clients on the best ways to improve their credit. And one of the quickest and easiest ways to build or even rebuild your credit is to get a credit card. So all of this data seems to suggest that despite bankruptcy itself having a negative impact on credit initially, those that choose to file for bankruptcy can rebound fairly quickly. While I wish I had more time to go into all of the nuances of this topic, I want to just conclude this presentation by stating that there's no easy solution to the struggles a survivor of financial abuse faces. Bankruptcy is just one potential solution to a very complex issue within the overall credit reporting system. Thank you, and I will take any questions.
And we can start with if the judges have any questions.
Hi, Brittany.
Hi.
That was a very good presentation.
Thank you.
Thank you so much. So I apologize if you cover this or you mentioned this in your presentation. How would a company be able to verify that someone actually has coerced debt, like, or they're actually a DV victim? Would they have to have access to police reports? Did something have to be filed in the past?
Yeah, so part of the process for seeking identity theft recovery is to not only contact all of the creditors that you're a victim of identity theft, but also contact the credit bureaus, file and create an identity theft report with the FTC, as well as filing a police report. So all of that steps that are required under identity theft recovery is required to be to be part of the dispute process with individual creditors so that they know that you've taken steps to document that you're an identity theft victim.
But you mentioned that once there's an issue, once it's known that, let's say the domestic violence victim knew of the debt or signed off on it or whatever, but it doesn't mean that it's not coerced, right? It could still mean that it's coerced. So my question is, how would they be able to verify, let's say this domestic violence victim is saying, look, yes, I know about this and I did sign off on it, but I was forced to because of domestic violence. Would there be additional proof required?
So just to make sure I understand your question, additional proof required under like the identity theft recovery option, is that what you mean?
Perhaps, yes.
Yeah, so the Fair Credit Reporting Act specifically says that it specifically defines identity theft and what that means. And if you know of the debt or coerced into it, that's specifically exempted from types of debt that would be allowed to be considered debts incurred through identity theft. And so if the victim knows and I guess verbalizes that in this process, that will limit that particular survivor from recovering.
We have a question from another judge, and we also have, Brittany, if you want to look in the chat, we have a question from the director of the local legal project. Professor Brieger,
In the Q&A.
while she's reading the chat, do you want to take a look at that?
Sure.
Oh, no, Professor Brieger, do you want to ask your question? I'm sorry.
Oh, sure. So Brittany, thank you so much. That was great. And I know you're not really talking about abusers using bankruptcy, but I have seen so many times where abusers threaten to file for bankruptcy. My understanding is child support is not dischargeable. You still have to pay child support even if you file for bankruptcy, but that doesn't mean that abusers aren't using that threat to unsuspecting victims who don't know that. Mm-hmm. So I just wondered if you could address that.
Sure. Yeah. So you are correct. The bankruptcy code defines domestic support obligations very broadly, and those are exempted from a discharge. So an abuser would not be able to shy away from those types of responsibilities. And I think with any area with finances, but particularly with credit, and as bankruptcy is related to a domestic violence survivor recovering from financial abuse, I think one of the biggest factors would be education, so that that victim will know what the limitations are within the bankruptcy system and know if the abuser is using that type of tactic to just continue with the control over that person. And I do see the Q&A in the chat. A bankruptcy proceeding, it depends on which chapter you're filing. Chapter 7 is typically the quickest because it is known as the clean slate type of bankruptcy. So this one typically will last really just a couple of months, really. Chapter 13, on the other hand, is a court-ordered repayment plan. And because that does take time to repay your debt during that process, statutorily, you have to have a payment plan in place for 3 to 5 years. And in part to your second part of your question, as far as foreseeing a way to create an expedited bankruptcy process, I think that's a great idea. Bankruptcy is a federal law, so it would require congressional impact and have that type of law passed on a congressional level. But I think that is definitely something that should be looked at more fully as an option to address coerced debt and financial abuse in these types of relationships.
That was so cool. Hi, Brittany. I'm also the time enforcer, so I'm going to say thank you all for, thank you, Brittany, for a wonderful presentation, and thanks everybody for questions. But to keep us not being here until 7 tonight, can I move on to the next person? All right. And that next person would be Matt Capizzuto, and he is going to be talking about the Violence Against Women Reauthorization Act of 2019 and the boyfriend loophole. Matt, are you ready?
Yes, I am.
All right.
Sorry, I'm just going to pin you real quick.
And I'm going to spotlight you. There we go.
All right. So my name is Matt Capizzuto. I am a 3L at Albany Law. I got interested in this topic when I was interning at a public defender's office about a year ago. I was in a local court, and a gentleman came in with a misdemeanor stalking allegation, and an order of protection was issued on the victim's behalf. The judge asked him if he owned any firearms, and he turned to my supervisor, who was also an Albany law grad, and asked if he had to answer the question honestly or not. And it kind of just made everyone in the courtroom feel very uncomfortable until the prosecutors spoke up and actually answered to the judge. I heard what he said. He asked if he had to answer that honestly, and thankfully he did have to answer that honestly. The other way that I got into this was because of that. I started looking into the laws and the reasons why he did have to answer that honestly. And in New York, it is not as much of an issue because along with 26 other states as of 2019, that loophole has been closed. So more or less, the boyfriend loophole is where if you are not sharing children with, living with, or married to the victim of your domestic violence crime, you may not be required to surrender your firearm. These are only for misdemeanor and violation offenses, though. So just real quick, the historical background. Obviously, VAWA was the Violence Against Women Act was passed in 1994, signed into law by President Bill Clinton on September 13th, reauthorized in 2000, 2005, and 2013. Up until 2013, it had very bipartisan support from both sides, but in 2013, there was some pushback, and it was obviously heightened in 2019 with the upcoming elections. Just briefly, some federal regulations that protect victims and that prohibit firearm ownership. First of all, anyone with a felony conviction is already prohibited from owning a firearm. But the 1996 Lautenberg Amendment prohibited domestic violence, those with misdemeanor DV offenses from purchasing, owning, or possessing firearms. The Brady Act established a 3-day waiting period for anyone who does not have results come back in the NICS, which is the FBI's database. Some problems that we still have with that: between 2002 and 2003, less than a third of domestic assault convictions were actually reported and entered into the NICS. In 2014, of the 2 million orders of protection that were listed in state databases, less than 1.5 million were actually registered into the federal databases. So above and beyond the boyfriend loophole being closed, we still have other problems that we need to actually meaningfully address. Again, the boyfriend loophole is an area where abusers who are not married to, do not have children in common with, or are not living with their victim and or intimate partner are not required to surrender their firearms and are not prohibited from purchasing, owning, or possessing them because of that inability to classify them as domestic violence crimes. This is an issue because according to many studies, but most specifically a 2003 multi-state case control study, the risk of femicide by an intimate partner increases by 500% when they have access to a firearm. Additionally, in 2008, the Bureau of Justice reported that the majority of IPV homicides are committed with firearms. And in 2011, the U.S. Department of Justice indicated that firearms are used more than any other weapon in domestic violence incidences. Another area where I found that we were missing the nail on the head, so to say, with these laws is with youths. Again, because most people at younger ages aren't married as soon, or they may not have children, they are really not taken into consideration in this. So out of a study of 700 youths that are injured in assaults between the ages of 14 and 24, 23 reported that they had possession of firearm for non-traditional purposes. As you can see, traditional purposes would be hunting, target shooting, and sporting activities. 83 of those respondents indicated that they had obtained those firearms illegally, and 17% said that they obtained them through plausibly legal methods. Obviously, there's other issues with the illegality of firearms and obtaining them, but between 2006 and 2015, 6,700 firearms were transferred to individuals prohibited from owning firearms due to DV records. So again, there's a lot that we need to do to actually close all of the loopholes. And additionally, nearly 50% of all female victims of IPV homicide requested or obtained an order of protection. So on April 10th, April 4th, 2019, Representative Karen Bass introduced her Violence Against Women reauthorization of 2019. Among the most relevant provisions that she had, she replaced the term intimate partner and changed the definition to include spouse, former spouse, co-parents, cohabitants, people who have cohabitated, dating partners or former dating partners, or anyone similarly protected in that jurisdiction, and also extended this prohibition to stalking, misdemeanor stalking convictions and orders of protection. This does a lot mainly in the 23 states who have not yet closed that loophole, and does a lot more to protect the victims of intimate partner violence, solely because it prevents the most significant risk that exists for them to have lethality in their cases. A companion bill was introduced to the Senate on November 13th, 2019. In sum and substance, it was the same as Karen Bass's bill, just the Senate companion version. However, it all but stalled and was pretty much just dropped by the Senate. Prior to that, House Republicans, even though it did pass in the House, reported that there were two so-called poison provisions, being that the boyfriend loophole is being closed and that stalking, misdemeanors, and order of protections would be prohibited from owning firearms. On November 20th, 2019, Senator from Iowa, Joni Ernst, introduced a competing bill to the Senate. The notable differences that she listed was that there were increases in grant funding to existing DV programs, but it omitted the boyfriend loophole and stalking misdemeanor prohibitions that I mentioned earlier. This is a very significant difference, as I will explain later on, because it just provides another avenue for people who are accused of or convicted of these misdemeanors to obtain firearms in plausibly legal ways where they really should not be owning firearms. The reason that my research indicated that she introduced such a companion bill had a lot to do with the lobbying efforts and oppositions that have historically and currently sort of pushed back on any firearm restrictions. Most notably in 1994, there was the classic pushback that VAWA doesn't equally protect male victims of domestic violence, despite the clear fact that women are 5 times more likely to be victims of intimate partner violence. But what I found more compelling was Senator Joni Ernst's very strong relationship with the NRA, and more specifically their Political Victory Fund. In recent years, between 2014 and 2018, the New York Times reported that the NRA spent $3.1 million attacking any candidates that were running against her in elections. She did, in fact, win her most recent election to retain her seat for the 2020 Senator of Iowa. Another thing that I found very impactful was the NRA's grading of politicians. I have a quote from Jason Umet, I'm pronouncing his name very poorly. I apologize for that. He's the chairman of the NRA Political Victory Fund. He stated that Joni Ernst is a combat-proven patriot and fighter for Iowans. She protects your fundamental right to keep and bear arms. Iowans who care about safety and security of their families have an easy choice. They should vote to re-elect Joni Ernst on November 3rd. Joni Ernst was herself a survivor of domestic violence, but for whatever reason in her research, she did not find a need to close the boyfriend loophole. Another issue that I found with the pushback was judicial indifference, which is essentially judges that are ignoring the law. Lisa May, who is a contributor to the Columbia Journal of Gender and Law, was observing local courts in February of 2003 in Missouri, and she cited 2 cases where the same judge did essentially things that were very uncomfortable for her. First, the judge credited the testimony of a severely battered woman who described her husband throwing her to the ground, threatening her with death, waking her in the middle of the night by holding her down and beating her. Despite crediting her testimony, the judge denied the order of protection and told her that changing her locks would allow her to remain safe, even though her abuser would have access to a firearm because it was only misdemeanor charges being alleged against him. And in the same day, the same judge denied an order of protection, and he cited the start of quail hunting season as a reason for doing it. And it's kind of the situations like that where judicial indiscretion and firearm culture are pushing back against the laws that we have, and they're really chopping down at our protection of women through prohibition of firearm ownership when it's necessary. So in my research, I found 3 states that have the best solutions, in my opinion. First being New York. CPL 37015 designates a procedure for misdemeanor crimes being designated as DV crimes. They allow for intimate relationships regardless of whether they live together anymore, whether they're related by consanguinity or affinity, to be classified as misdemeanors. California similarly has a definition where intimate associations primarily characterized by exception or affectional or sexual involvement independent of financial circumstances can be included. And then finally, my preferred method is Massachusetts system. They have an option for those who are in a substantive dating or engagement relationship, which shall be adjudged by a district, probate, or Boston municipal courts to consider factors for whether the relationship still exists. The factors are the length of time.
I'm just going to give you a little time warning here, okay? And I think Nina likes you too much to do it, but we have to move it along. Thank you.
The other thing that I found was very relevant with Massachusetts was that they also, through case law, extended that to online dating. Personally, I think that the Massachusetts option is the best because they have the most broad definition, and they also take into things like technology with online dating, as well as a need to better report orders of protection and greater transparency in campaign financing. And that is all. Any questions?
Matt, thank you for this presentation. It's so funny that you say quail hunting, because when I was prosecuting DV cases, they also did the same thing for deers and rifles, and where if you have to move your rifles to your mom's house or whatever. How do you close that? There's a loop within a loop here, right? Because the way that the court is notified as to the person having a gun is by the prosecutor or the defense attorney voluntarily giving that information. So how do you close that loop? Do you make it mandatory that they ask these questions? What would you suggest?
I would say that the judge absolutely has to make it mandatory, but in addition, I know New York State actually does have their own way to record whether someone does own a gun or not. I think it also has to come on the defense attorneys to not just understand their role in this, but to understand that allowing their client to not disclose whether they have a firearm is honestly doing more of an injustice to society and to the IPV victim than it is to just taking away their personal liberty interest, if you can call it that, in owning a firearm.
Thank you.
Matt, it's Casey. How do you prevent someone from getting a firearm after this? You know, they go to court, is there some, and they're not supposed to have a firearm because of all of this. How do you stop them from going and getting one? Is there some database or some way that they will be flagged immediately?
Yeah, so the FBI has the NICS database, which takes orders of protection and convictions for domestic violence and felonies. The problem with that is that under the Brady Act, if they do not return any results in three business days, I believe, they're no longer required to hold that firearm. I think making that go to like a week would be a better option, just as well as having a better system of consolidating them. One of the statistics I had up was, I want to say in 2014, that of the 2 million orders of protections in state databases, only 1.5 were in the federal NICS database. So it would just be better reporting to the federal authorities as well, and just more, I don't want to say more intrusive processes in the local courts, but at the same time, it's a civil process, so the standard of proof to remove a firearm is a little bit lower than it would be with a traditional like criminal conviction.
Thanks.
Eileen, you're muted.
Thank you very much. And I'm now going to introduce the next person, if they're ready. Cassidy, are you there?
Yes, I'm here.
Yay! Next up is Cassidy Milam, and her topic is Reforming but Ignoring, a look into New York's CPL Article 245 in the context of a domestic violence case. Thank you.
I'm going to share my screen real fast. Hi, everyone. As Nina said, my name is Cassidy Milam, and I am a current 3L and pro bono scholar with the Albany County DA's office, where I've accepted a postgraduate offer. Today, I'm going to be talking to you about the New York criminal discovery laws in the context of a domestic violence case. I chose this topic because I have always been interested in criminal law, and during my time in law school, I've interned with the Special Victims Unit in Albany County, along with the Domestic Violence Bureau in the Brooklyn DA's office. When I first started my internship, my 1L summer in SVU, the office was talking about these new reforms that were coming through and were to take place at the beginning of 2020. I was working in Brooklyn at the time when the reforms began, and I saw the flaws firsthand. My paper is currently pending publication with Albany Law Review, Volume 84. Starting from the beginning, New York was a common law jurisdiction for discovery practices until 1971, when CPL Article 240 was enacted. Within the next 9 years, the legislation significantly reformed it in 1980. It then took another 40 years for the major reform to occur, where Article 240 was completely repealed and replaced with Article 245. So what happened during those 40 years? Over-incarceration rates soared, wrongful convictions occurred, and long waits for trials were the results of the 1980 Article 240. The reform was needed, but it did come at a cost. So in April 2019, the legislation passed the bill in an unfunded mandate overhauling discovery. With it came bail reform and changes to the speedy trial requirements. There were amendments made in May 2020 that were met with some funding. There are many differences between Article 240 and Article 245, but during this presentation, I will only be discussing a few notable differences. First, Article 240 required that the defense demand discovery to be turned over. But now, under Article 245, at arraignment, the discovery statute is automatically triggered. If a defendant is in custody, the prosecution has 20 days to turn over all the information, and if the defendant is not in custody, then the information must be turned over within 30 days. The new law does allow for an extension of 30 days without a need of a motion. Second, broader amount of discovery is now required to be turned over. As a reference, Article 240 contains subsections A through K, but now Article 245 lists subsections A through U. All of these subsections contain at least one, if not more, items that have to be turned over. Third, Article 240 was coined the blindfold law because information was not required to be disclosed until trial. Therefore, a defendant could essentially be convicted on a plea without seeing the evidence against him or her. Although this was not the practice in many offices, it was what the statute read at the time. Therefore, Article 245 removed this blindfold and required that evidence be turned over within so many days of the plea. With all these changes, there were effects on a prosecutor, which have the ability to then affect the survivor of a domestic violence situation. Prosecutors describe the job as a seismic shift. Another extreme, paper pushing. Headlines came out in the early parts of 2020 discussing ADAs being paid an additional $60 to comply with these laws, along with many ADAs leaving Brooklyn due to all of the burden of complying with this law. The people may not announce ready until discovery has been complied with. Thus, a domestic violence case could be at risk of dismissal if at the conclusion of the speedy trial requirement, the people have failed to announce ready. These changes turned a prosecution's role into triaging cases to make sure the important ones and the high-level cases received attention. COVID brought another layer to this complex situation that I nor my paper have been able to address, as the long-term consequences are hard to determine at this point. In the criminal justice system, domestic violence survivors suffer at the hands of this new legislation. Domestic violence is a family offense in the criminal law. However, my paper and the presentation narrowly define domestic violence as intimate partner violence. Approximately 80% of domestic violence cases do not go forward because the victim does not want to participate. A main cause of this is safety. These new laws have caused fear for many. Prior to 2020, grand jury transcripts only had to be turned over as prior statements of a witness under Rosario material. Thus, if the case resulted in a guilty plea before trials and hearings, it is quite possible that a defendant would never know that a victim had spoken out against him or her. Article 245 now includes this to be required information to be turned over within the timeframes that I previously discussed. In domestic violence cases, cooperation can lead to more abuse. Thus, turning over grand jury transcripts too soon could result in less cooperation by a survivor or increase witness intimidation and abuse by the abuser. Next, witness contact information is required to be disclosed to the defendant and defense counsel. Now, this is an intimate partner relationship, so it's likely that the abuser already had ways of contacting the survivor. However, some victims may obtain different residences or phone numbers for safety reasons after an arrest has been made. Allowing a defendant access to a different method of communication opens the door up for further witness intimidation and abuse. Some DA's offices have used a program to essentially scramble, similar to how Uber and Lyft use phone numbers. And currently, case law has been split on whether this is considered adequate contact information allowable under the statute. Now, in domestic violence cases, an order of protection is typically requested at arraignment and granted by the judge. So although criminal charges may deter some abusers to not contact the survivor anymore, at the end of the day, it is simply a piece of paper telling them not to do so. In 2018, 14,000 charges stemmed from a violation of an order of protection. The legislation to address these safety concerns did enact CPL 24570 as a way to help protect victims through the means of a protective order. This would allow prosecutors to request information to be withheld from defendants and/or defense counsel upon a showing of good cause. Although a county court case has taken the step in the right direction out of Bronx County to lower the standard of risk required under Article 245, there is still a flaw with these protective orders. The prosecution must speak to the victim to even know what information needs to be protected, know if the case can go forward, and what they're facing. Thus, a victim of domestic violence may not feel safe coming forward with information, knowing that the protective order could be denied and the victim's information and cooperation could be discovered by the abuser. I just want to highlight this quote that speaks to how a victim is being subject to these laws that have just come through. In closing, I would like to discuss 4 proposals for future legislation. First, I suggest that grand jury transcripts should involve a judicial decision. Pennsylvania had an open file discovery system and began having serious witness intimidation issues. So then they came up to New York, researched our grand jury system, and enacted a grand jury system around that in Pennsylvania. However, they do not require their grand jury transcripts to be released until a judge decides whether there could be harm caused to any party. Second, I suggest that witness contact information be provided 30 days before trial, or in the alternative, amend the language of CPL 24520, which is where witness contact information is stated, to include domestic violence cases as an exclusion, similar to how it did with sexual assault cases in May of 2020. The reason I suggest 30 days is, one, within 30 days of trial, it's likely that you would know if you're going to trial at that point. And proponents of this bill looked at Texas as a model of open discovery. Texas, though, does not require contact information to be turned over until 20 days before trial. As a note to grand jury, Texas's grand jury is truly secretive and is never disclosed to the defendant, as there's no stenographer in the room. Third, the timeframe for turning over information should be 45 days for all cases, incarcerated or not. Currently, a question posed, which I have not found the answer to, is what happens on day 21 if a defendant is released from jail? Has the prosecutor violated the timeframe statute by not providing it within the 20 days, or has it now changed to 35 days? In addition, what if they are incarcerated on another case, but not this domestic violence case? Is it still 20 days, or is it at 35 at this point? These are flaws that legislation nor case law have fully addressed yet. I suggest still allowing that 30-day extension without a motion for any voluminous material. Lastly, Everything's a compromise and a give and take. In order to still hold prosecutors accountable, I suggest that the legislation make intentional discovery violations a crime. Thus, this will make sure that any wrongful convictions or negative stigmas due to intentional discovery violations are taken seriously and have repercussions. I know this was very quick and I'm unable to present and cover everything that was in my research, but I would like to thank you all for listening. And are there any questions? And if you have any that come up later, my email is also on the screen. Thank you.
Judges, does anybody want to ask a question?
Can you provide an example of what you'd consider an intentional violation of the discovery laws or statutes on behalf of a prosecutor?
So we've seen it through headlines where people have come out and there's been wrongful convictions in cases where a video could have been discovered and it just was never turned over or it was destroyed. If there is any maliciousness in the prosecution where something is not turned over that should have been, and then it's later destroyed and it's found out, that would be something that would be an intentional violation that I would see.
Okay, all right, I'll let someone, ask a question before I follow up, go.
To follow up with Adriel's question, so most of the time, prosecutors don't know that something is not there because police officers or the investigating party either don't tell them, don't know, or we don't even know it happened. And as you stated, victims are not forthcoming, right? So there's a fine line that we're creating, right? Like what is malicious? Do they ask and say, and that's enough? Or what would be the fine line that you would create to constitute maliciousness?
So the reason I suggest this is actually Georgia has this on the law, and there's two different ways that they have it. The maliciousness part actually increases it to the felony. Intentional or even not necessarily intentional, but knowledgeable failure to disclose is a misdemeanor in Georgia. So in cases where maybe the prosecutor doesn't know, we are told as prosecutors, if it's in the police hands, it can be imputed to us. And so while that's not necessarily intentional, it would be a failure on our part, which could just be maybe the misdemeanor level, or sometimes there's sanctions involved in all of the discovery. But as rising to the malicious part, it'd be where specifically it was either in our hands or we knew about it and did nothing to turn it over.
So I guess my thing is sanctions is one thing, but to rise to the level of criminal liability, I think is the other. And just as my experience as a prosecutor, and I'm sure Brenda would agree, there are lots of things that prosecutors just don't know in terms of, let's say, evidence or a video or a recording that an officer might have until maybe weeks or months later. So are you saying that someone should be criminally liable for something that they didn't know about or they couldn't have known about? I'm just trying to flesh that out.
Thank you for that. And no, if they don't know about it when it should have been turned over, that is something that just should be sanctionable as it is written in the law, but not necessarily rising to the criminal liability part. It is when when they become aware of it and have the knowledge of it, but then fail to then disclose it at that point is when it should at that point rise to the level of criminal liability.
All right, we are coming up on our 5-minute mark for questions. Anybody else?
I also want to just mention that if judges want to use chat as well, they're not prohibited from doing so. But I also am just learning so much from my alums and students together. So thanks, everybody.
Okay, I'm going to say to Cassidy, thank you so much for your presentation. I understand now why things seem different.
Thank you.
And I'm going to ask Joseph if you're ready.
Always ready.
Excellent. All right, and next up, before our break, would be Joseph Pidel, class of 21, and he is protecting victims of police-perpetrated domestic violence. That would be his topic.
Thank you, Nina. 1 second. Okay, hopefully everybody can see that. So good afternoon, everyone. My name is Joseph Pidel. I'll be discussing the obstacles surrounding victims of police-perpetrated domestic violence. Now, I was initially drawn to this topic after a class discussion on the Lautenberg Amendment, something I will be discussing later, but I just kept thinking of the consequences to the victim because of such an amendment. Now, before I begin, I do want to state that it is possible that while I speak, I might refer to a victim as a she and an abuser as a he. This is not to say that males are never victims, females are never abusers, but statistics significantly show that the abuser is more often a male and a victim is more often the female. To protect the people and reduce fear. This is the missions of police departments nationwide. Unfortunately, this is not always the case when a suspect is a member of law enforcement. Now, despite law enforcement families having a 40% higher risk of domestic violence incidents, the victim abusing officer is often not held accountable. Current police departments don't have specific procedures, screening mechanisms to overcome the conflicts that arise under such incidents. Simply put, the victim's safety is not always put first. Police officers have these unique abilities that make them some of the most dangerous domestic violence abusers. But what is it that makes these abusers so dangerous? Well, these officers go through intense training and have access to confidential databases and information. This could give them access to domestic violence victim shelters or even knowledge about reports made against themselves. The knowledge, skills, abilities, and access to information gives them this unique power to basically control their victims. Now, I'm not necessarily discussing why police officers abuse victims at a 40% higher rate. As suggested by a classmate in my domestic violence seminar class, Nora Baker, it is very possible that those officers who do abuse their intimate partners, maybe they struggle with mental health issues. And this is something that definitely needs further research, but helping those officers cope with those mental health issues could reduce the likelihood of officer-involved domestic violence incidents. But what I'm focusing on today are the various conflicts that arise under such incidents. Who does a victim report to? How will the responding officers handle the scene upon arrival?
Do you have a PowerPoint by any chance?
Is it not sharing?
No. Which is
Oh, that's
stuff.
funny. Sorry, guys. Let's try this again.
You're just trying to model what Professor Lynch used to do last semester where her
you see,
PowerPoint wasn't
Professor
sharing.
Lynch showed me how to do technology. Okay, can you guys see it now?
Yes.
Finally, I was curious why I couldn't see anybody's faces. Okay, so let's try this again. So who does a victim report to? How will the responding officers handle the scene upon arrival? And do judges and lawyers treat the defendant police officer differently? Before I mentioned the officer's connections within the police department, upon submitting a report of domestic abuse, the victim is putting her trust in law enforcement, but her abuser's role in law enforcement jeopardizes her safety. She's relying on those officers for her safety, but the abuser's colleagues trust the abuser. The abuser's colleagues work with him and they believe that they know him more. But perhaps the abuser laid a foundation with his colleagues that his intimate partner is, quote, crazy or, quote, out to get him. There are a number of ways for the abuser to discredit the victim before any report is even made, and this only puts the victim at a greater risk. The abuser's colleagues may believe the abuser's stories, and they may just not take the victim's report seriously. This could result in the colleague even learning of the report, and further abuse would result to the victim. The access police officers have to confidential information and the concept of police culture, where colleagues are expected to protect each other through loyalty, increases the likelihood that the abuser will learn of the victim's report. Now I want to tell you a story about Miss Desiree Martinez. Ms. Martinez contacted the Sanger Police Department to report that Clovis Police Department officer Kyle Pennington placed a pillow over her face and tried to choke her. Upon the responding police officer's arrival, a senior officer intervened, stated that Officer Pennington would not be arrested, and because Officer Pennington and his family were, quote, good people, and that he knew Pennington's dad was also a cop in a neighboring city. This is the perfect example of police family and police culture. The responding officers left. They did not arrest Pennington. The couple was sent back into their home where Pennington allegedly beat, sexually assaulted, and raped Miss Martinez. Pennington has continuously denied the allegations ever since. Now, I am not going to speak as to whether Pennington is guilty or not, but what I do want to focus on is the responding officer's failure to take the appropriate procedures to best protect the alleged victim upon arrival. Pennington's status as a police officer should not be considered in determining whether to arrest Pennington if he was guilty of domestic violence, nor should the senior officer's belief that Pennington and his family were, quote, good people. Police culture should not interfere with that mission police departments pride themselves on: protection of others, reduction of fear. Ms. Martinez's allegations were not taken seriously by all of the responding officers, and her safety was not put first. And Ms. Martinez's story is not the only one of this nature. It's just one for this short presentation. What's also sad is that a victim isn't done overcoming obstacles for safety, even if her abuser is arrested. First off, police officers work with prosecutors regularly. That's a conflict right there. Lawyers and judges have respect for the difficulty of the officer's job. And while police officers most definitely do have a difficult job, it is a dangerous precedent to potentially reduce charges, not pursue charges as heavily against an individual solely for the respect of their job and maybe because they work with that officer outside of this case. And just to complicate things a little further, begin to think, does the victim want her abuser to lose his job as a police officer? Under the Lautenberg Amendment, any individual charged with a misdemeanor crime of domestic violence may not possess a gun. Consider the consequences this may have on the victim. Think back to Brittany Bushman's presentation to start today. Victims are often manipulated to be financially dependent on the abuser. An abuser losing his job is an inadvertent punishment on the victim. While a study needs to be conducted into this issue alone to determine statistics as to how often an officer does lose his job, for now it's just worth acknowledging how deep the roots of this issue go. Now that we've briefly discussed the conflicts of interest that arise in police-perpetrated domestic violence incidents, we will now look at policies that current police departments have in place in response to these conflicts. The Chicago Police Department is one of the largest police departments nationwide. There was a study done of their department that found that approximately one in every 54 officers of their 13,500 member department had been involved in a domestic violence incident. This concerning statistic led the Chicago Police Department to become one of the leading departments in the country in implementing these policies that address such intimate partner violence. They created a 24-hour complaint desk, they created an independent investigation unit, and they created more outreach and advocacy services trying to better protect these victims. And while the New York Police Department is not as much of a leader in implementing these strict policies, the department did take initiative after an independent investigation found that punishments for physical domestic violence incidents were often less severe than just discourtesy to a supervisor. That's pretty concerning, especially considering how big New York Police Department is. Now, in response to the this finding, the NYPD proposed guidelines that provide presumptive penalties for such physical domestic violence incidents. Fortunately, actually most police departments nationwide do not have policies in place to better protect victims of officer-involved domestic violence incidents from those conflicts that we've discussed. The IACP model policy was created to basically lay out numerous procedures, definitions, policies that serve as suggestions for police departments nationwide. And this model policy provides a victim-centered approach, specifically where the abuser is a member of law enforcement. And as I mentioned, not many police departments have such policies in place, but even fewer have implemented the suggestions provided by this model policy. And just to look back to Chicago's police department, they were one of the few that have implemented parts of this policy.
So, minute.
Okay, thank you. Now, with respect to reporting, the main goal remains that victim remains protecting the victim. This may require better screening, sending reports to neighboring jurisdictions that the abuser has less relations with. This may not eliminate the entire conflict due to the, oh, sorry, I just dropped my chair, due to the existence of police culture, but it is a start. And the last things that I really want to discuss is just this incident response team. There really needs to be a shift in attitude towards disciplining an abuser. That is a police officer. Having such dangerous acts be overlooked and lacking accountability just jeopardizes their mottos. And in responding to these incidents, there needs to be specific procedures. But as with the story of Ms. Martinez and Officer Pennington, those procedures are not always followed, which is where having social workers present who could better protect the interests of the victim and ensure that the appropriate procedures are being followed would be great. And I just included police review boards because police review boards are becoming bigger and bigger, especially with all the social justice issues today, and giving them more power to address these conflicts would result in more accountability. I spoke a lot and I know my time is basically over. So I just want to say, victims of police-perpetrated domestic violence rely on law enforcement agencies for protection, but without the implementation of policies that address these conflicts, are these victims truly being protected from their abuser to the best of law enforcement's abilities? Thank you.
Thank you. And do we have any questions from the audience? Panelists, judges?
I have a question. Is there any way to ever really get around the complex relationship between prosecutors and police officers when handling these types of cases?
That's a very good question, and I've thought back to this, and while I can only say I've done limited research into this, in my head, which I take it for what it's worth because it's an opinion, I do think that maybe having the Attorney General step in or having special prosecutor unit within the district attorney's office would be a good idea. A group that doesn't work with the police officers as frequently may be a good idea for overcoming this. Now, I don't think this does exist currently, so it would be a big task nationwide, but I do think I think that would be big progress.
Thank you.
I do not see anything in the Q&A. Does anybody else have questions? Melissa, Professor Bigger.
Good job, Joe. I was just mentioned, I know this, you didn't really touch upon this, but I have often heard about police-perpetrated domestic violence, and that the very things we look for in police officers are the very things that make one a good batterer, if you will, right? So maybe like that toxic masculinity and that sort of the very thing, so the very things that sort of encourage a strong police officer might be the very things that are dangerous for victims. Can you speak to that at all?
Yeah, definitely. So I'm with you. I think that's part of what brought me into this. I thought it was very interesting, and I know police reform is as big as it is right now. It just made sense because I think it is a broad issue. And I do personally think that the root goes deep. I think it goes back to training and recruitment. I think that there needs to be better training to make them aware of this issue at the very start. And it comes, there's so many questions, and this is just more police reform as a whole than necessarily this point, but consider demilitarization and all that kind of stuff, and that's where it gets really complicated, because right now officers are trained for certain scenarios, and those scenarios definitely come around, and it's concerning because you have to balance it out on both ends for safety of police officers, but also protection of the society, I guess. Thank
Joe,
you.
we have 2 questions in the Q&A. I don't know if you can see them or if you would like me to read them.
Now there's 3 questions.
Okay. Are you muted, Joe?
Technology is not my friend today. So what about other means of investigations? That's a very good question. I think, so I ended up, so I briefly mentioned the whole use of social workers. There was in my paper, and if anybody that wants to see it can email me, I ended up discussing it was a practice study in Virginia where they ended up bring social workers as a part of as like a second response team, and they would attend and conduct an investigation with the police officers. So that was something that they did put, and it showed that procedures were more often followed. Now, I don't know why that isn't the permanent procedure and why that hasn't become more popular yet, because I think it was about 10 years ago, but I did find it interesting to find something like that. So that would be my suggestion for other means of investigations. And has there been any discussion of turning over a case to the state police if the alleged perpetrator is a member of a local police department? It's a very good question. I did not look into that specifically. I did mention neighboring jurisdictions. I do think that departments try to send over where they can get ahead of it. They try to send over those conflicts. Sometimes I did read somewhere that officers don't always know of the conflict until they arrive at the scene. So that could be complicated at times. But it depends on the predicament. But I do think that would be a great suggestion to at least limit police culture to an extent, right? So I think that's every question.
There's
Anybody
another
else?
question.
Oh, sorry,
Final
Michelle.
question, and then we probably need to move along.
Take a break.
I need to get some water. What issues have you seen regarding intersectionality? Are police more likely to believe white cisgender women survivors versus minority survivors? And what extra steps, if any, would you like to see law enforcement offices do to protect those minority survivors? That is a very, very good question, Michelle. To be honest, I don't have a good answer. I think that once again, it's as deep as this is. I'm sure that there is an issue with with basically the privileges that white individuals have. I think that does exist. I'm sure it does. I don't know any statistics. I have nothing like that to support that, but I'm sure that does exist. But what I would say is that I think you have to make sure that, I think the goal from my end is if you can have a diverse group of social workers involved, or somebody to just make those procedures more strict and hold those officers accountable for their actions. Hopefully, in an ideal world, they would take everybody's allegations at least seriously, but I guess fingers crossed, right?
Okay, well, that was going to have to be the last question. Joe, thank you very much. You did a great job. The agenda has us stopping about a minute and a half ago, but I think to keep things on track, let us reconvene at 2:35. It's about 8 minutes from now, enough to run away, get a drink of water, and take a stretch. So
Thanks,
thank you,
everybody.
and we'll see you at 2:35. It says 2:28 my time if you want to sync your watches.
That's what I have too. And to the students who just spoke, amazing work. And the last question by Michelle Zaladick, real interesting, Michelle. And I know what I'm talking on later today at Rutgers is prosecutors' power and racial justice. So yeah. Ooh, Alicia has her hand up. Is that on purpose, Dean Ouellette?
No, I'm having mystery here. Nope, I don't even have the ability to put my hand up, so I have no idea.
Oh no, your hand is up.
I can't see anyone. I can just,
But you know
I
what?
can see.
That's okay. Just so
I'm
you know,
lowering your hand.
I had some issues this morning. I spent about an hour with Carl for the later on today, and I realized it was advice I was getting was for hard versus laptop, but we figured it out.
Dean Ouellette.
I've been watching and listening, but I can't see you or.
That's okay.
Dean
We love
Ouellette.
we love your face.
Dean Ouellette, for some reason, although you did get a panelist invite, it looks like you are actually in as an attendee. I can press a button and flip you into panelist mode. You might have to relog in.
Okay, I'll sign out and relog in. Okay.
No, I'm going to just stay right there and do whatever the machine tells you, as we all should at all times.
Nice.
All right, I'm gonna.
I was promoted.
The system work. I'm sorry, I didn't catch you earlier.
And I didn't get to thank Jeff and everyone else at the beginning. You just needed to move along. I would like to take 1 minute at 2:35 just to say the thank yous that I moved along at the beginning, very briefly. Is that okay, Nina?
Please, and thank you.
Okay.
I'm running to get more water, like Joe.
Yes,
I just
bye.
desperately. Oh, I got 5 minutes. I can pee too. This is great.
it is 2:35, so I'm going to say some thank yous here. First of all, this originated because of the amazing research work, presentations, dedication, diligence, collaboration with each other, robust discussion that came out of the domestic violence seminars over the past couple of years, as well as independent projects. And really, I was so impressed with what was coming from the students. I threw out the idea of doing this. The incomparable, energetic, ever positive Mina Mirzai ran with this idea, got the able organizational assistance of the office manager, paralegal, tech wizard, and amazing feminist, Nina Ropi, to make this happen. We reached out to career placement and institutional advancement, and Jeff Sieber and David Jaden and Mary Walsh Fitzpatrick and communications and ITS, and everybody said, yes, let's do it. We can do it. And we did. And so I needed to thank everyone who has made today possible before we begin again. And again, a real thank you to the judges who are putting in incredible time. I do want to mention that the Women's Leadership Institute, which was founded by our alum, Ms. Patillo de Cossard, is funding 3 awards, which will be provided to 3 students, a first and second and third, in a combination of both their presentation and their research paper. And so the judges are diligently asking questions and judging, and Professor Ouellette, who is doing that as well, is being somehow Albany Law School is not allowing her to participate here with us and show her face. But we saw her for a second during the break, and we're working to, and that's okay. We love her picture there. And so without further ado, I believe it's Ms. Kristen Davis.
Kristen, you're on mute, and Kristen will be presenting on protecting domestic violence survivors in the Christian church. And it looks like she has, so you're all set. Can we hear you?
I'm just trying to get it in slideshow mode.
All right, good job.
Can everybody see my screen?
What? There it is. Yes. Oh, it just went away.
Okay. I'm going to try that again.
Okay.
Do you want it to be in presenter view?
No, I was just trying to have it open. The entire thing just closed. I don't know why.
Yeah, well, that sometimes happens.
I have something to say while Kristen's working for a second. I just wanted to remind everybody that I believe I have all your final papers, but if I don't, as soon as you finish talking, please make sure you email them to me, because when this presentation is finished, I will be emailing them to the paper judges. So for review. All right.
So Kristen and I had help doing this morning. We'll do one adjustment, and then we'll have you go ahead with the PowerPoint, and we'll imagine your fabulous PowerPoint.
Okay.
Are you using one monitor or 2?
I'm using one monitor.
Okay. Go into your PowerPoint application, end the slideshow. So go into, your bottom there, find the PowerPoint application. End the slideshow, and oh, now there it is. Now, you had it in presenter mode when I looked at it. Is that what you want? No, you're good now?
We're just gonna
let's just keep it in. We'll see your slides on the side. That's not a problem. Let's do that for now. And I will tell you later why that happens. Okay.
Okay. Sorry about that, guys. Good afternoon, everyone. Welcome back to our second session of presenters. My name is Kristen Davis, and I'm here to talk to you guys about a specific type of domestic violence called spiritual abuse. Before we get started, I do want to define some terminology to make sure we're all on the same page. First, I'm going to be using the term survivor when I'm talking about victims of domestic violence. And I'm also going to be using the female pronouns like Joe referenced earlier. Additionally, I'm going to be referring to churches and church leadership throughout my presentation. And when I'm referring to churches or church leadership, I'm talking about denominations of Christianity in America that worship in a public space, follow the basic tenets of Christianity, and use a Christian Bible. So before this class, I had never heard of the term spiritual abuse or thought about religion within the greater context of domestic violence. But when I was flipping through the table of contents looking for a paper topic, I saw an article on religion and domestic violence. And immediately, a memory came into my mind that happened last summer where a woman from my Bible study class came to the class with a large bruise on her arm. After we realized that it came from her husband, the room was flooded with sentiments like prayer can solve all things and God never gives you more than you can endure. It wasn't until I was taking this domestic violence seminar class that I realized how problematic those statements are when dealing with survivors. And that's why I chose to devote my paper topic to the concept of spiritual abuse. So what is spiritual abuse? So spiritual abuse is a tactic used by abusers in order to control or manipulate a survivor through that survivor's religion. And the way it works is they'll use religious beliefs, they'll use religious texts, or just the societal norms within that church community in order to force the survivor to adhere to their demands. And the reason why it works is the abuser will equate going against the abuser with going against the religion, so that the survivor believes that they're the same exact thing and that she can't go against the abuser without also going against her religion. Sometimes they'll block access to religious groups. They can do this by blocking access to transportation or by simply physically preventing the survivor from leaving the house to attend church services. There's also this concept of biblical wifely duty that it's not really well defined, but it's this idea that a good Christian woman fulfills her biblical wifely duty, and abusers will use this concept to guilt their wives into doing whatever they say because they want to purport to be the good Christian woman. One important thing to note about spiritual abuse is it doesn't always rise to the level of physical abuse. And this can create a kind of trap that affects the entire context of domestic violence, where survivors don't think they're being abused because they haven't been physically harmed. But we know that conduct does not have to be physical in order to be abusive. So instead of trying to define all the similarities and differences between all the different denominations of Christianity in America, I thought it would be more helpful to go through the three main ways of analyzing the Bible, because the interpretation that a survivor follows is how that abuser is able to assert his authority. So there are three main ways. So the first way is the literalist Christian view. So they view the text of the Bible to be the true voice of God, and they believe every word in the Bible is true. So this is the most problematic view when attempting to combat domestic spiritual abuse, because there are multiple scriptures throughout the Bible that treat women as the property of their male counterparts. So it's important that church leaders are making it clear that it's forbidden to use scripture against another person to try to combat that effect of the literalist Christian view. The second is a conservative Christian view. So they view the text of the Bible to be words written by humans, but they're inspired by God. So they don't believe that every specific word of the Bible comes directly from God himself or herself, depending on your views. So the conservative Christian view still has potential issues because abusers can argue that problematic scriptures are still inspired by God. So what church leaders want to do is they want to make sure they make it clear to their practitioners that God is never endorsing violence against women to kind of combat spiritual abuse under that view. And then the third is the liberal Christian view. So they view the text of the Bible as words, just simple words that humans have written about God. And what they do is they use it as more of a set of guidelines rather than a hard set rule. So this is the most helpful when combating spiritual abuse, because for two reasons. One, it acknowledges that human error is possible and we don't know exactly what the original words were. And two, it allows the reader to really contextualize the Bible's message within that scope of the larger modern society. So those are the three main ways that different denominations will view the Bible, and what church leaders need to do is acknowledge how their view is either helping or hurting survivors. So for the next section, I kind of want to talk about theological implications that can happen. So the two main problematic schools of thought come from the nature of God and nature of human beings. So under the nature of God, there are two main ways of looking at it. The first, emphasizing God's omnipotence. So this is really harmful to survivors because it suggests that God is actually willing their suffering, and it leads to advice like God will never give you more than you can endure. So what you want to do with this is you want to make sure spiritual leaders acknowledge that each practitioner is going to make their own decisions, and each practitioner is responsible for how their decisions impact others. And what this accountability will do is it will show that God is not intentionally harming the survivor, and that this is something of human nature and not of divine intervention. So the second school of thought under nature of God is focusing on Jesus' suffering. So what this does, it actually minimizes a woman's suffering because she hasn't suffered as much as Jesus. And it leads to questions like, can't you bear some suffering too? And so with this one, what you really want to, you would use the same sort of analysis I was talking about earlier, where you want to focus on how each practitioner is responsible for their own decisions. And the important thing about both of these schools of thought under nature of God is they both focus on how the abuser is, they both focus on like the abuse, how the survivor is reacting to the abuse, instead of how the abuser is abusing a person. I found that through my research, a lot of the implications and theological interpretations really do focus on the survivor rather than holding the abuser accountable. So the other theological implication that comes into play with spiritual abuse is the nature of human beings. Some abusers will argue that women are underneath men because they were made second. It's just something that a lot of abusers seem to believe. What spiritual leaders can do to combat this is emphasize that the order of creation does not actually create a subservient position for women, and that all humans are equal under God to kind of create that even playing field. All right, so for this section, I've been mentioning problematic scriptures so many times during this presentation. So I thought I would give you some of the more problematic scriptures I was able to find from the Bible and talk through some ways that you would be able to get past those. So the first one comes from 1 Corinthians, let your women keep silence in churches, for it is not permitted unto them to speak, but they are commanded to be under obedience. So one way spiritual leaders would be able to combat this is to kind of take women out of the context and just make it more, people should not be speaking during a church service, or people should not, to expand it to include all people and not specifically just women. The next one is Ephesians and Titus. They kind of both go together. The first one talks about wives submitting themselves to their husband, and the second one talks about how you need to be good and obedient to your husbands. So for both of these, what you want to first do is acknowledge that these scriptures were written during a time period where women were the absolute property of men, and speaking out against a man would have harsh consequences for women. And I think putting that historical context into a sermon, for example, can explain why some of these scriptures have this type of advice. And whenever you go back to that modern society and you put it into the scope of modern society, then you can see how some of the former advice isn't really relevant to today's standards. Additionally, for the submit yourself unto your husband as to your Lord, sometimes people will interpret this scripture as simply being, is that my 1 minute mark, Nina?
Yes.
Thank you. So sometimes people will use this scripture as or they will say that this just means that the man is the spiritual head of the woman and not the actual head of all the matters. An important thing to note about that is that can have very bad ramifications as well, because you can use your position as spiritual head to still influence the victim. I have more analysis on these. If you guys would like to email me, I will give that to you. But since we have 1 minute, I want to talk about my recommendations. So my recommendations are a three-pronged plan that spiritual leaders should implement. First, mandatory comprehensive training. One problem with the comprehensive training right now is that it's only the spiritual leader, it's not the greater church leadership. And this is problematic because depending on the size of the church, it's possible that that person doesn't have access to the main spiritual leader, or they might simply not feel comfortable. So my recommendation is that needs to be expanded and held yearly. Ideally, the training will be done with the use of community-based domestic violence organizations in order to strengthen the relationship between the two in case survivors need to access those resources. My second prong is stringent policies. There should be stringent policies that apply regardless of who the person is. And my third is increased transparency, including churches should publish a yearly report made publicly available that disclose every domestic violence report that's made in that church. Thank you.
And your last is, are there any questions?
Mm-hmm.
Hey, Kristen, this was a great presentation. Thank you so much. My question is going along the lines that you were going on. There is this stigma of divorce in the church, right? And you know, how we should be working it out if God sanctioned it, right? So how do you get around that, knowing that there is domestic violence issues, and how do you present that to church leadership?
That's a great, that is a great question. It actually kind of allows me to explain something I had to skip. So under my stringent policies, two of my recommendations kind of address that problem where if the couple wants to stay together or they don't want to get divorced. So one of them is a mandatory counseling session. So this is anytime there's a domestic violence report in the church, there should be a mandatory counseling session with both the abuser and survivor separately and together in order to ascertain how the problem is going to be handled. Additionally, if the couple decides to remain together, I'm advocating that there needs to be mandatory couples counseling for at least 1 year just to keep a good handle of the situation. And on a positive note, it depends on what denomination you are, obviously, the idea of divorce, but Catholics who have historically been pretty conservative about divorce, the Pope actually said that you are allowed to get a divorce if you're in an abusive relationship.
Kristen, there's a question in the question and answer box.
Yeah. So how do you enforce those changes? That's very difficult because we have a separation of church and state. So there are a couple of different ways. I was going to go more into that into my paper, but I realized there was going to be too much to deal with that. So right now, my recommendations are not enforced. They are recommendations that, similar to how VAWA put out a role of faith leaders, they put out a recommendations and guidelines book. So this really expands on that guidelines book, so it's not necessarily enforced. If I were to do additional research, I would see if maybe we can do some of the policies maybe could be contingent upon their tax exempt status. But honestly, I haven't done the legal research required to give an adequate answer there. I can't hear you, Professor Lynch.
You're muted, Professor Lynch.
Kristen is referring, for those of you who haven't taken the seminar, the Violence Against Women Office of the Department of Justice. I was going to ask her that question, but I'm just going to answer it.
Do we have any other questions? Or are we going to make our timetable? Excellent. All right, Kristen, thank you so much. Our next presenter is also one of the organizers of this event, Mina Mirzai, and she will be speaking on the impact and challenges mental health and domestic violence. Mina, are you ready?
I am ready. Thank you so much, Nina. I'm just gonna
Awesome.
slideshow, because can everyone see the slideshow all right?
Yes.
Okay, wonderful. Well, good afternoon, everyone. I am discussing the intersection between domestic violence and mental health. And to begin, we have to have a baseline in terms of our discussion. There are definitions of domestic violence and definitions of mental health. The ones that I have incorporated as part of my research is based on the Department of Justice and based on the World Health Organization. And what that intersection brings us is that these definitions center on the individual survivor and specifically how environmental effects can impact an individual. Survivors of domestic violence are survivors of trauma. And with this often leads to a wide variety of physical, pardon me. Sorry, my computer was being odd. Pardon me, a wide variety of ramifications on an individual's emotional, spiritual, physical, and mental health. So the mental health ramifications of domestic violence are yet again another part of the cycle of abuse too many individuals will experience, unfortunately. And so moving here into domestic violence in terms of the numbers, to your right, I have average calls to the National Domestic Violence Hotline. These are daily calls on average versus holiday calls. This is on a 3-year period. You can see the prevalence, unfortunately, on holidays of calls to the National Domestic Violence Hotline. And 2 million women per year are estimated on average to be assaulted by their partners. Again, this number is actually estimated to be twice of what is actually reported. And battered women account for 25% or a quarter of women utilizing a psychiatric emergency service or emergency psychiatric services in emergency departments across this country. Furthermore, 60 to 90% of battered women have mental health disorders. So one of the reasons that my research was inspired by taking a highlight on domestic violence and mental health is because we don't recognize sometimes that when we're talking about individuals who struggle with mental health, there is a huge population of individuals who are grappling with mental health issues who are survivors of abuse. And it's important to remember that, as I will discuss later, in terms of the implications of this and the ramifications of this on implementing health tactics to help survivors move on from their abuse after they have survived their abuse. And so when we talk about these mental health issues, what am I exactly speaking of? Well, medical literature has a lot of information about, generally speaking, the 3 major mental health issues that survivors of domestic violence experience. They are namely depression, anxiety, and post-traumatic stress disorder. Now, to your right, these are live MRIs of brains experiencing and not experiencing each of these mental health issues. So to the left, respectively, you have an individual who is depressed, or you have an individual who is experiencing a what is called an episode of PTSD. And to the right, you can see the difference in coloration. We don't have to be physicians to see the psychosomatic and physiological impact that these mental health issues have on survivors. And more importantly, I've noticed that in the literature, mental health is described so abstractly. What is mental health? Is it self-care? Is it actually implementing some sort of regime for oneself that can, help you grapple with the day-to-day? But in fact, I think these scans show us the true physiological impact that mental health issues have. And these are the issues that survivors of domestic violence grapple with on a daily basis as they attempt to overcome their abuse. And so when it comes to treatment for victims of domestic violence, we have 2 major categories. Of course, there's professional mental health support, which most of us are aware of, and that includes, as I'll discuss, therapy. And there's something called emotional safety plans. So with respect to professional mental health support and talking about therapy, there are one-on-one sessions and there are group sessions. It has been noted, and I will discuss this a little bit more in my next point, but one-on-one sessions have been found to be much more effective for victims of domestic violence as compared to group sessions. While group sessions are helpful, imagine interacting with someone as a care provider or as an advocate who has had their trust broken by someone that they trust, an intimate partner or a loved one. And so for that reason, building that patient-physician relationship is even easier or even more attainable when that patient has one-on-one interaction with a survivor of abuse. And so in that way, it has been shown that one-on-one sessions are often much more helpful and effective, although of course they take a lot of time and that there's a limited number of providers, as we know in this country, when it comes to mental health, which we must address with our medical system, which we are attempting to. And so as compared to group sessions. And secondarily, mental health providers specifically trained in domestic violence, foreshadowing with this idea of training, see a 97% follow-up rate amongst survivors. The significance of this, when DV survivors notice that their care provider is specially trained in interacting with them, empathizing with them, understanding how they are cognizing everything that is going on in their lives, there's a higher incidence of them continuing treatment, and that enhances the road to recovery. With respect to emotional safety plans, these are generally built out, typically with physicians, but also with outside advocates, with survivors, involving a 4-step technique: learning, addressing, feeling, and support. Like most of us, we like to have a plan in case things don't go as we like. Right now my computer just froze up on me, and my backup was to basically escape and then resubmit my PowerPoint, and that worked for me. Similarly, but very differently, victims of domestic violence who are overcoming their abuse on a day-to-day basis face a number of issues that they sometimes can't expect. When that episode of PTSD comes on, when on a certain day they might be feeling more depressed. These are real issues. And so emotional safety plans have been found to be effective plan Bs for victims to understand not only how they're feeling, but who they can reach out to when they're feeling like on a certain day or at a certain moment, they need that extra support. And so now, obviously, I know we're amongst a group of students and attorneys. And so we ask ourselves, we look kind of intra per se, and we say, what can lawyers do? What can lawyers do with respect to mental health, domestic violence, and the implications of each with respect to the future of survivors overcoming abuse? And importantly, as I mentioned before, with 97% follow-up amongst specialized physicians and working with victims of domestic violence. Similarly, it has been found and advocated by the American Bar Association that targeted training is highly effective amongst practitioners, amongst prosecutors, amongst advocates for victims of domestic violence to assure that they are better able to not only develop a relationship with a victim, but also help that victim in terms of the victim's willingness to work with their advocate to come to a solution or a resolution with respect to the issues that they are having. Now, unfortunately, I say all this and you would think, well, of course, isn't this a requirement? It is not. Currently, across jurisdictions in the United States, there is not a requirement that individuals be trained in domestic violence, specific training when working with victims. And creating this requirement, as has been advocated and as we've seen in other professions such as medicine, would be greatly beneficial for advocates and for prosecutors alike in working with victims on the front lines. And so a proposed option for this type of targeted training are intra-institutional assessments and also schooling requirements. Once again, the American Bar Association has highlighted that like school, like Albany Law School, which I am very proud to be a part of, like programs like the Domestic Violence Seminar and the Domestic Violence Prosecution Hybrid, which Professor Lynch leads on a yearly basis, these programs better implement and inform students from the baseline of their learning to empathize with victims. No matter what area of the law they end up entering into, the ability to empathize, the ability to pay attention to details and understand the risks and challenges that victims endure in telling their stories is something that is incredibly beneficial to every law student. And so The American Bar Association has advocated that law schools try, like Albany Law School has, although they didn't mention Albany Law School specifically in the report, they allude to law schools like Albany Law that already have incredible DV programs implemented that are flourishing and informing students about what needs to occur when dealing with and advocating for a victim of domestic violence. And furthermore, I'd like to discuss, now that we've talked about what lawyers can do, kind of looking inwards, looking outwards, what can be done with respect to victims of domestic violence seeking mental health evaluations and processing their medical needs beyond, of course, the realm that we are able to, as lawyers in the legal realm, attend to. And this, of course, alludes more now to VAWA funding. And as Mr. Matt Capizzuto mentioned in his presentation, the Violence Against Women Act still needs to be reauthorized. But the Violence Against Women Act is given funding by the Office on Violence Against Women, or the OVW. This office, when it fully was implemented back in 2019, administered nearly $559 million of grant monies. So it's important to keep in mind, $559 million. This is across all 50 states and territories with respect to Violence Against Women Act specific issues and programming. But specifically, unfortunately, amongst that $559 million, only $5.36 million as of fiscal year 2019 were actually granted to individuals with respect to programming for mental health resources, such as access to mental health professionals for underserved communities. And why this is incredibly saddening and important is because the largest uninsured population of Americans today are minority communities, underserved communities. Coincidingly, women who experience domestic violence most often are also women in minority communities and underserved communities. And so this intersection is an unfortunate coincidence which must be addressed. And it's important that in order to help better address the intersection between domestic violence and mental health, that Violence Against Women Act funding specific to mental health is increased. 5.36 million, less than 1% of the nearly 560 million, which is granted in general to VAWA funding, is nowhere near enough to address the impending crisis that, of course, mental health has on survivors of domestic violence to assure a future for them beyond their abuse. And with that, thank you for dealing with my technical difficulties. If you have any questions, I would so appreciate them.
Excellent, Mina. Thank you very much.
Thank you.
And let's see if we have some questions from the panelists, the judges, the audience. Professor Brieger?
I don't have my question formulated yet. I'm just so excited about this presentation because it's something near and dear to my heart. And I guess I'm just trying to think of, what else do you recommend as a way to really bridge that gap between survivors of trauma and the link to mental health? And, beyond just training law students, we need to train courts and lawyers and law enforcement, because those are folks that are dealing with these survivors on a daily basis. And how do we reach them? Do we mandate CLEs for lawyers to understand the implications of mental health and trauma? How does this work? Just such a great job and such an important issue, but I feel like it doesn't get enough airtime. It's such a critical issue.
Thank you, Professor. I can't agree with you more on all of your points. First of all, with respect to this idea of specialized training, medical professionals are required to go to residency. Some of them move into a fellowship prior to their actually being full-on physicians. And there's an importance to that because, like everyone on this call almost can attest to, it's the lived experience of being a lawyer that actually gets you to the knowledge base that you have to actually implement the kind of work that you need to do to be the lawyer that you are. It's incredible how much learning we do on the job as attorneys. Law school prepares us for that basis of that learning. And with respect to police officers, as you mentioned, or court officials or liaisons or whomever you're speaking about, again, we already have that gap. We don't have a residency. We don't have a fellowship. In that way, it's a much larger institutional question about how early do we allow professionals to access victims? How do we shield victims from individuals who are not prepared to speak to them? You know, and that probably happens more commonly than we think. You know, individuals who are not part of specialized DV programs, for example, at Albany Law School, or maybe at other schools that don't offer specialized DV programs, will still end up going and working in DA's offices and being, you know, thrown on the job and asked, interact with this victim. And I think that's where we have to really focus our thoughts, is on how we continue to train these students.
Mina, there's a question in the Q&A that sort of also relates to this topic.
Absolutely. Do judges have to take domestic violence counseling? So that's a fabulous question. So I am a little bit biased because I did my undergrad in Nebraska, and I actually found anecdotally that in Nebraska and in certain other states, judges who are in family courts actually do receive some CLE type training in DV counseling. It's a very interesting kind of like offshoot. And again, I wish it was mandated. I wish it was something that everyone had to take and everyone had to do, almost like we are in a way at Albany Law School, although we're not even required. It's just such a fabulous program. We all, you know, hop on board when we can in order to take it. But I think that it is out there. I think that there needs to be more of an awareness, and conversations like this one and programs like this one help to raise awareness about the importance of being aware of victims and how to advocate best for them. I hope that answered the question.
You know, when you were
that Professor Brieger has trained New York State judges on a number of subjects, and thank God she does.
Brenda, were you talking?
Yeah, you know, when you run for president, just remember us one day, okay?
Oh my gosh.
But I think one other thing that would make your PowerPoint and your presentation really something that I would consider is there's specific domestic violence courts, like for example in Albany, there's a domestic violence court, which is the city court is run by Judge Farrell. Well, we could also have a mental health court or something that could be ran by someone who's already trained to be sensitive to domestic violence issues, but also trained as a mental health professional and knows of those issues. So that's just a suggestion on my end.
Absolutely. Absolutely. Could not agree more.
Do we have time for one more question? Sorry.
Yes, actually we do. One more minute.
So for the lawyers that routinely deal with victims of domestic violence and are doing this on a day-to-day basis, are there resources for their mental health? Because if they're not in a good place, they can't help someone get in a good place.
Absolutely.
So can you talk a little bit about that if you know?
Absolutely. That is an important question. Vicarious trauma is real. Lawyers experience it, physicians experience it, nurses experience it, anyone who deals with people experience it, quite frankly. Vicarious trauma is not spoken of enough when advocates themselves become victimized in a way because they are constantly emotionally being drained. I know specifically the American Bar Association has chosen to tackle vicarious trauma head on. There are a lot of outreach groups and support circles. There are even support circles within our own community. I mean, if you're on any number of listservs on about a monthly basis, we receive lawyers supporting lawyers. These are all programs that are meant to have attorneys come together and talk about their experiences. You know, obviously in a closed way, it can be hard to talk about, but I also think something to keep in mind is I have relied on my supervisors to be, in a way, people that I can talk to about what I'm experiencing. So we do see cases that are horrifying and saddening. And all it takes is picking up the phone and speaking to your fellow peer about it to make you realize that you're not alone. And I think that that's probably one of the most damaging parts of vicarious trauma is if you feel alone, because you have to know you're not. And so I think that there are support circles out there, and I encourage everyone at any time who feels a sense that their work is overburdening their emotional or mental health to seek those resources. Absolutely.
All right. Well, Mina, thank you so much. You did a wonderful job in your presentation as well as in all of this. So, and at this point in time, we would like to keep it moving to our final presenter, Dominique Vaccaro. And she is going to be presenting on fueling the abuser's narrative, understanding misogyny, psychological manipulation, and reactive abuse in the criminal justice system. Dominique, are you there? And looks like you're doing something awesome.
Yes, do you see the PowerPoint?
I do, thank you.
Okay, perfect, thank you. So my paper and presentation is multidisciplinary. So I focus on sociology, psychology, and legal concepts and how the three intertwine in the domestic violence context. So my main arguments of my paper was that the internalized or ingrained misogyny within the criminal justice system in general, just through experience of life socially, it kind of impedes the process of proper justice to domestic violence victims in the fact that it enables abusers and invalidates their feelings if someone is to think that a victim's overreacting. My second argument is that psychological abuse is so important and it's often overlooked and passively addressed in cases in terms of just saying, oh, and she also suffered psychological abuse, but it's never identified and its effects are often misunderstood unless you experience it personally or you have training. My third point is that the criminal justice system, like Kristen had touched on in her presentation, it's very focused in my research I found on the reaction of the victims rather than the abuser themselves. And that really takes away from accountability. And it speaks to victim blame theory, which is in my next slide. So I began my paper by talking about misogyny, specifically the historical perceptions of women as being expected to be kind of passive and calm and resolve issues in a way that is not overreacting. So often if a woman reacts very emotionally, her reaction is considered irrational. So Unmasking the Abuser is a 17-minute clip, so I can't show any of it, but in it, it speaks to victim blame theory because Dina McMillan, she also is a domestic violence survivor. And in the presentation, she speaks about all of the ways to identify an abuser. She kind of alludes to the fact it was definitely good intention to say, oh, look for these signs so this doesn't happen to you, but it kind of expressed the message, at least to me, that domestic violence is preventable. And I don't think that's the case because no matter how educated you are, it can happen to you. So for psychological manipulation tactics, the main ones I focused on were gaslighting, minimizing, and dog whistling. I included the power of and control wheel because it does address minimizing, but it does not address gaslighting or dog whistling. So gaslighting is basically a distortion of the victim's reality. So the abuser will try to move the perception to their reality rather than the victim. So if the victim confronts the abuser, he could say things like, oh, you're crazy, or that never happened, or are you sure? And this creates the distorted reality for the victim and memory fog. So in the criminal justice context, it's hard to believe a victim when she doesn't really know what happened because all of her memories are just distorted and she tends to adhere to what the abuser says. Minimizing, just briefly, the definition, making light of the abuse, it's basically when the abuser says you could have had it worse. So in an example, I would say if the abuser hits the victim and she doesn't bruise or she doesn't have a break, he could say, well, at least I didn't hospitalize you. And both situations are horrible, but it kind of conditions the victim into thinking that she doesn't have it that bad, and that prevents her from seeking help. So dog whistling is kind of difficult to explain. It's used in the political context. I didn't find it anywhere in the domestic violence context, but I included this image of this cute dog because it's basically saying, well, it originated from the idea that a dog whistle, the dogs hear on a different frequency that humans cannot. So they know something that we don't. So with dog whistling, it's like kind of a messed up inside joke, but it's not a joke. It's between the abuser and the victim. So the example that I used in my essay is if a police were to respond to a domestic violence call between a victim and an abuser, and the victim for months begged the abuser to get therapy with her, and he just turned it on her and said, gaslighted her and said, oh, well, you're the one who needs therapy, not me. And then the police shows up to diffuse the argument, and the abuser suggests, oh, we should go to therapy. I was thinking that we'll take it into our own hands. The victim will be visibly enraged and look to the police officer as if she is not cooperating. But in hindsight, she knows that she begged for this for so long, and he's just being performative in front of the police. So reactive abuse is huge. I focus a lot about it on my paper. There's not much research on it at all. And if it is referred to, it's called violence resistance. And it's often mistaken for mutual abuse, because in a situation of reactive abuse, it is when the abuser will constantly provoke the victim with abuse, and then finally the victim will lash out, and then he could point to her and say, look, she is also abusive, or she is the one who's abusive. Because with psychological manipulation, it's difficult to detect what's happening, and it's often easy to be judgmental towards the victim. So this could result in wrongful convictions of a victim, or unsympathetic responses by courts to say, oh, well, you could hold your own, you fought back, or you're abusive as well, so why are you complaining? It also very much invalidates the victim's experience, because for all this time she was being abused, and she's seeking help from the criminal justice system only to be turned away to say she's also abusive. So criminal case examples I focus on. So I guess I'll start with People v. Marchant because it was first. So People v. Marchant, in this case, the victim and the abuser were fighting after a night of drinking. They were in the defendant's apartment. They were in the abuser's apartment, sorry. And he was chasing her around the house. She was locking herself in several rooms to try to get away from him, and he kept busting open the door. So finally she armed herself with a knife and ended up stabbing him to death because she believed it was either his life or her life. She was very scared. So in that case, she was originally convicted of manslaughter in the first degree by the jury. They were not sympathetic. They didn't feel that she was justified in her defense to use deadly force. And then actually, this is one of the first cases to express sympathy to the domestic violence victim, because on appeal, the judge actually reversed the conviction and dismissed the indictment. But I still think, in my perception, this speaks to how high the threshold is for defending yourself, and how judgmental it is when a woman actually does fight back, or a domestic violence victim. So, and then in the People v. Adamando case, this was a case where the victim suffered years of abuse by her boyfriend, sexually, physically. He used to record him sexually abusing her and then post it on websites. And during the trial, she actually ended up getting convicted in 2020 of second-degree murder. And during the trial, the prosecutor tried to frame it in a way where she self-inflicted the injuries, and she was lying, but because everybody in the community knew him as this nice guy, but everybody close to her saw the bruises. So in both cases, I think this represents an extreme form of reactive abuse, murder, and it's interesting to see the lack of sympathy. So my policy implications, I first said that we should have school programs. I know it can't reverse the current state of the criminal justice system, who's already in it, like Nina had talked about, like possible programs for them as well. But school programs to learn about unhealthy relationships and healthy relationships, how to differentiate, a law that criminalizes gaslighting. So that was originally in the United Kingdom, and reactive abuse as a justification defense instead of battered woman syndrome or self-defense. So the goal in all of this, I would say, is to steer away from pinning the victim as the abuser just because she finally couldn't take it anymore. So for school programs, the target audience, I would say, is high school and college students, because in my research, it was found that most abuse occurs between these ages. Obviously, it can happen later, but it starts in these ages. And I feel like these are ages where serious relationships start arising. So it's very important to target that audience because these people can become potential jury members as well as criminal justice actors. So for criminalizing gaslighting, the gaslighting statute in the United Kingdom actually came under the Serious Crimes Act of 2015, but it was enacted in 2019 after a surge of domestic violence cases in 2017 to 2018. I didn't go too much into why there was a surge of domestic violence cases in 2017 and 2018, but it basically criminalizes coercive and controlling behavior, but it is referred to as the gaslighting statute. So I think looking at the text, I included it for reference, but I think that New York should go off of this framework to some extent, but not fully. I think it's very important to define gaslighting, minimizing, and dog whistling, not only so the victim could understand what actually happened to her once the abuser is charged, but also because it validates the experience of the victim, because it's very easy for the victim not to get grief for the psychological harm, and the psychological harm almost always predates the physical harm, and its lasting effects are way longer than physical abuse, with the exception of murder. So current civil remedies, just briefly, I said intentional infliction of emotional distress doesn't really give much to criminal justice victims. Then just to wrap up really quickly, reactive abuse as a justification defense. So currently I feel like battered woman syndrome, when I was doing research, it wasn't given much positive reaction when victims tried to use it. I think that when you're using reactive abuse, it identifies the fact that the victim actually did abuse the abuser by murdering the abuser, or in other cases, but it justifies it by saying it's reactive. It was because she was in such turmoil, like mental turmoil, physical turmoil for so long, that it is justified. And then, why is this important? So abusers will always try to make victims look crazy or flip the script to make it like they are abusing them. These policy implications, I think, can be important in identifying the true aggressor instead of pinning the victim as the aggressor, and it will validate the trauma that they experienced.
All right, that sounds wonderful. Do you want to ask for questions?
Sorry, that was my last slide, I forgot. Does anybody have any questions?
I'm trying to see if you can unshare screen, we might be able to see a few more.
Oh,
panelists,
okay.
Judges.
So I know that Delaney Reeves, actually, you cited Delaney Reeves Knapp in your article and her law review article. And Delaney, you talked a little bit about the Marchand case in your piece, and wondering if you have any questions about where she's now taking your gaslighting, but you evaluated it in terms of traditional self-defense and gaslighting, and where do you think this concept of you might want to have questions with her about reactive abuse?
Yeah, I mean, I think the term, and I think you pointed this out, I am having like a visceral reaction to the term reactive abuse, just because obviously we know domestic violence requires a power imbalance, and victims acting out in self-defense, classifying it as a form of abuse, I think is problematic. But I'm wondering if, I know you compared to the criminal statute for gaslighting. Have you looked at any other methods of how this is being addressed by courts or other types of policies or entities?
I didn't go too far into that. I just know that reactive abuse is often not seen as like a defense. I know it was like in none of the literature, and when I was looking at it, it was very unsympathetic towards victims. I'm not sure if that answers your question, but I didn't go too much into that. I kind of focused on the fact that even though I understand how you said it does sound problematic to say it is abuse, but I feel like when I was looking at battered women syndrome, the way they framed it was kind of like a helpless victim. And having that kind of mindset, I feel like people would perceive her not to react in such a way. So even though it is problematic to say that it is abuse, I think coupled with the word reactive, it is self-justifying. That's how I thought about it.
Yeah, I think it's something that people have struggled to identify and figure out like an empowering way to classify these particular experiences, because that was also what I came across in my research is the classification of a battered woman and how that's kind of been rejected by practitioners today, but we're still trying to find like the right terminology, I think, that's representative of their experiences. So thank you for your research.
With the Q&A, do I press answer live? I can't hear you, you're muted.
You can just
Professor
speak.
Brieger also has her hand up.
Oh, okay. Do you want me to do that one first? I don't mind.
Yeah,
Either
talk
way.
to Professor Brieger and then we'll answer the Q&A.
Okay, that's fine with me. Great job, Dominique. Really, really good work. And
thank you.
I guess I'm going to push back a tiny bit on one thing that you talked about, which is to start working on some of these issues at the high school and college level, which I completely agree. But I would say it needs to be earlier. A lot of the research that I'm working on talks about middle school, even early education, because some of the things you're talking about, that psychological abuse, that starts so young, you know, especially with social media, that starts so young. And by the time they're in college, we've kind of lost some of that. So to me, you get to the kids before they're in those intimate relationships. You get to them when they're just starting to think about intimate relationships to prevent those patterns from starting.
Mm-hmm. Yes, I think that's important to point out. That's definitely a better suggestion than I had, but.
And as for the Q&A, you just read the question and answer it. I'll press the buttons.
Okay, so how would you prove gaslighting when stalking is hard to prove? That is a very good question. I actually struggled with it because sometimes it's even hard to define gaslighting in general. The only way I was thinking is like evidence by the victim recording the abuser, but sometimes it's so slight it's hard to detect. So I didn't get too much into that, but I definitely did think about how difficult it would be to prove it, especially with dog whistling, how I talked about it is so slight. It's like barely hard to detect because it's only between the abuser and the victim. And then it's like, who do we believe? So very good question. I have thought about it as well.
I have a question for you, Dominique. Is it challenging to be getting a joint degree as a master's in criminal law where the way you're encouraged to think and write about interdisciplinary, and then in law school classes where we just are really focusing you on what's the self-defense law, how does this apply, and how did that influence the writing of this paper?
So I think it actually does help. I like having both backings because I did criminal justice in undergrad as well. I got my bachelor's. And I think it gave me a good overall framework of the criminal justice system. And I know I want to do criminal law upon graduation. So now that we focus on these concepts in domestic violence, in criminal law, I think I had, I guess, not like a bias, but an understanding background of some of these concepts before I came into this paper. So I definitely do have them in mind always while I'm in law school. And I do see an overlap in the cases that I talked about in my undergrad and now in my master's, as well as during my JD.
Do we have any more questions? All right. Then Professor Lynch, I just want to wish you good luck this afternoon. And Mina, if you would like to step forward and say a few words to our friends before we all take a break for the weekend.
Of course, and I'll make it quick because I'm this buffer between everyone and their weekends. So thank you all for attending. Good luck to Professor Lynch. She is headed to her next presentation. That is the nature of Professor Lynch. I would like to thank everyone. I'd like to say that more than 24 people, faculty, staff, students, and alumni were involved in the creation and execution of this symposia. And please know that this symposia is only a small example of the incredible scholarship and dedication and passion that I am lucky to say I am peer to amongst my peers at this institution. And thank you so much to our judges. Thank you so much for your time. And thank you all for joining us today. It has been an incredible honor and pleasure to be in front of you. And my last thank you once again is to the Women's Leadership Initiative. Thank you so much for helping support us in creating this program and executing this program today. We are incredibly grateful for your support. Thank you all so much. Have a good weekend.
I just sent a text saying that this has been recorded. If you would like to take a look at it later, you can please just reach out to me via email and I will send you a link. Best of luck. Congratulations to all who presented. You did great. Thank you. Bye.